God damn it. I was muted the whole fucking time. All right. Well, God dang it. Let's try it again, shall we? Damn it. I'm Chris, and this is Bama Law. We are going to do a deep dive again into Wong Kim Ark. This is the 1898 case that set the birthright citizenship into play. It dealt with the Chinese Exclusion Act. That's going to play a part that I believe was set in. I think when I just read it, I think it was 1892, 1882. So we brought all the Chinese over, said, come on over. And they said, oh, thank you very much. I'd like to be here. And then we had to build our railroads and said, afuera. And they said, oh, no, fuck you. I'm not going nowhere. And then they built all their shitty walks and they said, we're not going anywhere. And one of those people was Mr. Ark, whom actually was born in San Francisco. He was born here to Chinese parents who were subjects of the Emperor of China. That's important because the Emperor of China, and I'm sure it's still to this way today with the CCP, you can't just give up your citizenship to China. It doesn't work that way. In fact, the court goes into that, and I think it's Justice Harlan who does the dissent. And he talks about it and say, hey, wait a minute, you can't subject yourself to the jurisdiction fully of the U.S. You can't even give up your citizenship. So Wong and his family, from what I can gather, I know he came back. I'm not sure that they did. They were here legally. They were here prior to that act. They were here for whatever reason, probably to build the railroad too, maybe to set up a shitty walk and take a autopathe. So Wong comes back to the United States. He's on a boat, can't get off the boat. Can't get off the boat. Customs says, no, you can't get off the boat. You're not a U.S. citizen. Chinese Exclusion Act applies. Get the fuck out. He's like, I don't think so. No, I was born here, buddy. I was born in San Francisco. And I get to come on. I get to come back. And so he was locked on the ship and filed a habeas corpus petition, obviously through a lawyer. And that's what the habeas corpus is meant to do, bring the body forth, make sure that people are not being detained illegally. Unfortunately, it gets the hell abused by prisoners, especially prisoners who are on death row. They'll do them constantly. They'll do them just about anyway, constantly, but especially those on death row. All right, so we're going to use IRAC, a modified version. Issue, rule, analysis, conclusion. That's what you're going to use in law school. So anybody who's watching in law school, you're going to fit right in. You're going to come be right at home. All right, so the issue in the case was, did the 14th Amendment of the U.S. Constitution, and after we do this, I am going to go in and show quotes from the actual men who drafted the amendment, and because they had contemporaneous interviews that were done contemporaneous to this case, and they gave opinions on it as to whom it was supposed to have applied. So it's kind of like taking a balloon and stretching it over something. Well, yeah, it's going to stretch. You can stretch it as far as until it pops. At some point, it's going to pop. Well, we're at the point. It's going to pop. Yes, you can take it and stretch it over everybody and make everybody a happy-go-lucky, oh, kumbaya, everybody's going to be covered by it. At some point, it's going to fail. And we're there now. It's failed. It doesn't work. It wasn't meant to be this inclusive citizenship. That's my opinion. And hopefully you'll be here, and hopefully I'll convince you at the end. If not, hey, feel free to leave a comment, like, dislike, don't care. That's fine, whichever. The issue is, does the 14th Amendment of the U.S. Constitution grant citizenship to individuals born in the U.S. regardless of their nationality or status of their parents? The court at the time ruled in 1898, yes, it did, based upon the following. Literally, this is it. Very simple sentence. All persons born or naturalized in the United States subject to the jurisdiction thereof, which is going to become the key catching point even today, subject to the jurisdiction thereof. What the hell does that even mean? Does that just mean you're here? What if you don't? What if you don't subject yourself? What if you don't say, hey, I'm an American. I'm going to follow the American law. I'm going to, number one, follow the law, not come in illegally. I have no allegiance to another prince, principality, king, emperor, etc., or foreign state. Only of these United States. Therefore, I've come in legally. I've subjected myself to the jurisdiction thereof. I have a kid. The kid is now a citizen too. All right. Even if the parent's not. That's the argument. That's my guess. I think that's where it'll turn on the head of a dime, is that it's going to be, what does subject to the jurisdiction thereof actually mean? That, there we go. What does this mean? I think that's going to be the issue. Reasoning of the court. The court interpreted the phrase subject to the jurisdiction thereof to mean all individuals, all of them, all born in the U.S. except those not fully subject to U.S. law. Again, what the hell does that mean? They don't go into enough detail on it, such as children of foreign diplomats or enemy occupiers. Obviously, somebody who's here, an army occupying, invading like Pancho Villa did, popping babies out, aren't supposed to be getting citizenship. But you can make the same argument with illegals. What's the difference? If you have an invading army and you have an illegal, they're both invading. If they're by the millions, what? Because just because a state says, go do this, this is where you should go, and they do it, but they claim, I'm just here for the money. Is it really any different because they don't have arms? Is that what turns everything? It's just arms? I don't think so. Maybe so. Yeah, it's going to be an uphill battle for the Trump administration if they can get themselves out of the Epstein shit to even get it to be changed. But I think that's what they're going to have to argue. They're going to have to. Yeah, relax, sweater. Sorry. I fixed it. Sorry. I'm so stupid. I fixed it. Yeah, good. I can text too. Sweet. All right. So hopefully there's sound now. It's got it on my end. I don't know. You're on YouTube as well. So if you're still there, please let me know. I would appreciate it. Otherwise, it will suck if I go through this whole damn video and find out there's no goddamn sound. I'm going to be really pissed. Really pissed. Oh, what do you mean only Rumble Studio? Private. No, damn it. All. Let's see. I fixed it, I think. Okay. Well, shit. It's using my other account now. Oh, well. It's the best I can do. Is there sound? Shit. Did it work? Oh, wait. There I am. Is there sound? Hopefully someone will respond. I appreciate it. Thanks for sweater. I appreciate it. It's good to have you. Good to have you. Hope you stay. Hope you stay. All right. So we're back into the reasoning. Such as children of foreign diplomats, we learned about that. Okay. The court leaned on the common law principle of jus soli. Now, that's a common law principle, which, mind you, the Brits don't even use for citizenship determination. Don't know why they thought it was a great idea. I have no idea. It doesn't make any sense. I think they thought, well, the Chinese are being screwed over. These guys are similar to today's argument. These guys have been here. They were here legally. These guys aren't today, but at this time they were here legally and then excluded. And that we can't just say, well, everybody born here is not a citizen. So we're just going to use the 14th Amendment. We're going to really open up the what it means for all persons born or naturalized in the U.S. because I don't think that's what it meant. And I know that the framers, for the most part, maybe except for one, also didn't mean it. They specifically thought it only applied to one group of people that would be deprived of citizenship, even post War Between the States. All right, let's go on. Conclusion. Supreme Court's decision in Wong Kim Ark established a critical precedent affirming the constitutional principle of jus soli, granting citizenship to nearly all individuals in the U.S., regardless of their parents' immigration or nationality status. That's the problem we're facing today. Remember, his parents were legal. They were legal. And they had been here for a while. Obviously, the guy was 20 years old in 1898, so he had been here a while. I mean, obviously, he had been here a while, and his parents had been here a while. The ruling solidified the 14th Amendment's expansive interpretation which again, I don't think it was expansive. It applied to just one group of people, which we'll get to. Ensuring that birthright citizenship serves as a foundational element of American identity and inclusion. However, the decision also invites continued legal and political debate over the modern implications of this principle, particularly in the context of unauthorized immigration and involving national policies. A counterargument in favor of limiting birthright citizenship. The intent of the amendment. Here's, again, it's going to get yucky for people because it's going to deal with slavery. We're going to have to face it. At some point, we're going to have to face it. This is what's going to happen. It was designed to guarantee citizenship to the former enslaved Negro individuals and their descendants. That's their term, not mine. We're going to read that here in a minute. Not to establish a universal birthright citizenship. It only applied to former slaves and their children. That's it. The context in which it was enacted did not account for modern complexities of immigration or illegal entry, subject to the jurisdiction thereof. All right, so let's get to pink. Subject to the jurisdiction thereof. What does it mean? Oh, good. Love the voices. Lower the voices. Relax sweater. I'm going to say thank you. Hopefully it'll pop up. I'm trying to do it on I'm using Rumble Studio, which does both. Sort of. Like I can't chat as, it's weird. I don't know. I can't chat as I can't chat as myself, my channel name under Rumble, which is really bizarre. Yeah. It uses my actual account name. Yeah. It's really weird. So I thought they had fixed it to where I could chat as just me, Bama Law, but apparently I can only do it on YouTube. So let's see. All right, let's continue. This phrase, subject to the jurisdiction thereof, can be interpreted narrowly to exclude children of illegal aliens, as such parents have not fully subjected themselves to the U.S. laws by entering and remaining in a country unlawfully. Illegal presence undermines the principles of voluntary allegiance required to invoke full jurisdiction. And I've said it before in a prior video. I can't believe it's 21 minutes already, and I apologize for the first few minutes screw up. I remember seeing a guy's citizenship certificate, and it was out of Mobile County, Alabama, circuit court. And it listed a bunch, you had to absolve your allegiance to all principalities, princes, kings, etc., countries. And then it had a blank space, and it had written the Tsar of Russia. And it was like 1903, I think, when the guy came in. So it was conferred by the state of Alabama, which is the 14th Amendment. You're a citizen of the state in which you reside and of these United States. So it's by fiat with the U.S. So that could get in. And honestly, if that's the way it goes, we got to amend it. Because I think at that point we have another problem of, what do we do when California starts saying, you're a citizen, you're a citizen, you're a citizen, you're a citizen? Full faith and credit clause kicks in. It's a problem. These guys never dreamed of this. Ever. They never dreamed of this. They were just trying to fix an unjust system that had been done to people, the slave trade and slavery. That's it. Encouraging of lawful immigration, providing citizenship to children of illegals. I want to get my yellow back here. Of illegal aliens creates a potential incentive for unauthorized entry, undermining the rule of law and immigration processes. Restricting birthright citizenship would reinforce respect for U.S. immigration laws. There's also a resource burden. Granting citizenship to children of illegal aliens places significant strain on public resources. Healthcare. Go to the freaking ER. Just go to your local ER. Aside from the fact you'll see a bunch of freaking idiot rednecks sitting there going, oh, doc, my kid's sick with a cold. You're going to see a lot of no habla speak English because they're sick. And instead of going to a doc in the box, they know they can get care at the ER by law. It's a strain. It's a big strain. Social services, God dang it. You go down to, in Alabama, it's called DHR, Department of Human Resources. You go down there for your welfare, and you're going to be, that's all you're going to see. is Hispanics. I mean, I'm just being, that's a truth. It's not a lie. It's a truth. Some are legal, most are not. And they don't care. They just give it out anyway, or they used to. So it's a big deal. Resource burdening is a problem, and it's something we all face every day. Many developed nations, including most of Europe, do not follow jus soli, and instead confer it based on jus sanguinis, right of blood, or parental citizenship. The UK is the same way, and they've even nicked it down to where I think if you were born in a Commonwealth country prior to 78, then you were entitled to UK citizenship itself. After that, you were just a citizen of Canada. You had a passport. Now, your passport, you look at a Commonwealth country of the UK, it will say it gives them the right to come and go to any other Commonwealth country, the UK, etc., but it doesn't give them citizenship, period. Prevention of abuse. We have anchor babies. We have an anchor baby problem. That is our problem. I don't care who you are. You have to admit that it exists. Critics argue that automatic citizenship creates an avenue for birth tourism. That happens. The Chinese come here all the time. They come all the time. And they'll have a baby. They'll show up at 9 months, not even supposed to travel. They will show up, plop it out, get the certificate, and go home. And then the child's raised as a Chinese loyal citizen and comes back to the United States going, I have citizenship. We don't know if they're subjecting themselves to the lawfully to the jurisdiction of the United States. My guess is no. I'm sure some are. I'm sure many are. But a lot aren't. Their first and only loyalty is to the CCP. That's a problem. Okay, thanks, Relax Sweater. I appreciate it. Oh, you like that? I probably shouldn't do it. I'm probably going to get banned for it. That'd probably be my luck. Oh, what you banned for? Oh, I banned for talking like a Chinese man. I'm so sorry. You go fuck yourself. Fuck yourself. My aunt's Vietnamese, so I grew up hearing it. Christopher, you stop making fun of me. I can hear it in my head as we speak, or as I speak. Love her to death. I hate commies. Commies suck. I make fun. I make fun of everyone. So if you don't like it, suffer. Don't care. That's just me. South Park is a great thing. In fact, it's on tonight. Shit, just dawned on me. I better hurry and finish. Critics argue that automatic citizenship creates an avenue for birth tourism, a strategic entry by non-citizens seeking to exploit the system. Removing the automatic birthright citizenship of children for children of illegal aliens could prevent such practices. Now, while Ark affirmed birthright citizenship under the 14th Amendment, its application to modern immigration scenarios involving illegal entry remains a matter of interpretation and potential legislative reform. Now, let's get to the dissent. That's what's more important. Because although it's not a good way to start your Supreme Court argument, they're going to have to. They're just going to have to, which is probably going to get. I think, on contrary to a lot of law tubers, I have a feeling it'll be receptive with Alito and Thomas. And it may not be as far as the argument, but I think the outcome will be. I just don't think it's going to be one of these 8-1, 9-1 cases. I think it's going to be a 6-3. I could be wrong. Probably am. I'm wrong about judges a lot because they're human and they suck. Most judges suck because they're human. They just don't. They'll either hide behind the law to not do the right thing, or they'll try to use the law to do the right thing when they're not supposed to. Anyway, well, let's get to the dissent. I think it was Justice Fuller and Harlan, if I'm not mistaken. That was the two. Allegiance and jurisdiction. Justice Fuller argued that the phrase subject to the jurisdiction thereof in the 14th Amendment should not simply mean being physically present. It should require deeper legal allegiance to the United States. Hence why I said this is what they're going to have to probably use as the dissent and say, hey, guys, this has been a bad idea for 130 years. This has to be fixed. Or 20, 27 years, 127. He contended, Justice Fuller contended that Ark's parents are as subjects of the Emperor of China owed their primary allegiance to China and not the United States, which every illegal immigrant coming here, that's the problem. You're illegal. Yeah, you're not here legally. You cannot give primary allegiance unless you have renounced your citizenship of that state or foreign country or government, but you're still here illegally. So then you'd be even dumber, because then you'd be like the only dude coming in going, yeah, I don't want to have a country. I just want to be myself and live nowhere. So, it's a little more difficult, I think, when you talk about people here and it's like, okay, you're here illegally. You've got to renounce your citizenship in order to even start the process. Well, okay, where do they go? Like, I don't have the perfect answer to this. No one did, or no one does. It's a problem. I think they got to go home and reapply. And then we have to do our job as caretakers of this country and actually process applications. That's the problem. I remember in law school, I took an immigration course, and it was like, let's see, was it 05? Was it 05? Hang on, I got to do my math. 07, I think it was. We were 25 years behind processing Mexican, straight up, honest to God, people from Mexico wanting a visa to come here to live under a green card status. 25 years. Like, I don't know about you, but screw it. I'm not waiting. I know that I can get in. I know it's not hard. I know they're not going to do anything to me. I'm going. I don't blame them. I don't blame any of them for wanting it. I just want them to come here and subject themselves to our jurisdiction and have allegiance to these United States. Not can be out in the damn street with a Mexican flag waving it. And really that's really the one you see the most of. I don't remember the last time I've seen a Honduran flag or El Salvadorian or Peruvian. I definitely haven't seen Pinochet giving out helicopter rides to these people from Peru. So I guess Peru. All right, Pinochet was Peru. That reference, in case you don't know, that means they used to take you up in a helicopter. They'd give you a little view of the territory, and then, well, he's not a problem no more. That's a helicopter tour. Pinochet was big time on that. He loved it. Not a good dude. But it's a funny joke. Okay. Justice Harlan contended that Wong Kim Ark, I don't know why, I swear it should be like Kim Wong Ark. His parents, as subject to the Emperor of China, owe their primary allegiance to China, not the U.S., and therefore their child should not be considered subject to the U.S. jurisdiction in the full constitutional sense. Further dissent was authored, as well as, here we are. Harlan, Justice Harlan, expressed strong disagreement with the majority's interpretation of the 14th Amendment Citizenship Clause. The dissent argued that children born to parents who owe allegiance to a foreign power, such as non-citizens, should not automatically be granted U.S. citizenship under the 14th Amendment. One of the quotes, I think this is Justice Harlan's quote, the allegiance which they owe the Emperor of China necessarily qualified their obedience to the laws of the United States, and the citizenship of their children born in this country should be similarly qualified. Rejection of birthright citizenship for aliens. The dissent criticized the majority for relying heavily on English common law and argued that the U.S. Constitution should not automatically grant citizenship to children of foreign nationals, especially if their parents did not have lawful allegiance to the U.S. Justice Fuller emphasized the idea that citizenship should depend on the political and the legal status of the parent. That's what they're going to have to do today. They're going to have to argue that today. They don't have a choice. I mean, that's otherwise I don't see this changing. Now, granted, here's the kicker of all of this. And if I remember, I'll go through the 14th Amendment and read it in its whole. Congress has the ability to enforce it by legislation. Granted, they can't really just change it by with legislation. Man, they sure as in damn hell can make some inroads as to what the Congress wants and intends for the amendment to cover. Whether or not the court will do it, I don't know. No one does yet. But they can sure as hell pass laws to make it where it says, hey, idiots, this is what we mean by, subjecting themselves to the full jurisdiction of the United States. Can't be dual citizen. That may kill it. They could kill that and say, you can't do that to start with. You have to just be a U.S. citizen. You have to give up everything, which is what his name was Charles Denneberg. He owned a jewelry store in Birmingham, Alabama, named Levy's Jewelers. Still there to this day. But if you go into the store to the far right, they probably still have his citizenship certificate still up posted. He had to. He had to. He didn't get dual citizenry just because he came here. Congress could change that, though. They could say, if you want to get citizenship now, you can't have dual citizenry. However, once you get it, if you want to get it, we will allow it for these countries. Canada, Mexico, UK, India, whatever. They could do a handful. They could do all of them. It's up to Congress and how they want to do that. For another quote, Justice Fuller, it's unreasonable to conclude that those who framed and adopted the amendment intended to bring under its protection all alien children born in this country. I think that's self-explanatory. I think that's what most people think. And it's, again, the court doing its typical mental gymnastics that they pull to, again, try to right a wrong that they really had no ability or shouldn't have tried to right. They weren't dealing with the freed former slaves. We were not dealing with a grandchild of a slave that had been freed in like Mississippi, where Mississippi said, them and their kid are citizens, but we're not going to classify them as citizens. Therefore, they don't have U.S. citizenship. Remember, it didn't flow the way it does today. It wasn't U.S. to the state. It was the state to the United States. So you had to get state citizenship first. And then it became by fiat up until 1906, I think, with one of the, not the first immigration acts, but the ones that began to give us formation of today's laws were passed. I think it was 1904, 1906. Impact of parental status. Justice Fuller expressed concern about the implication of granting automatic citizenship to children of a foreign national, regardless of their status. He viewed this as inconsistent with the sovereignty and self-determination of these United States, arguing it would allow foreign governments to indirectly influence U.S. citizenship. My. How that one came to fruition. Wow. I guess we need to call it Nostradamus Fuller, because he got that one dead on. Policy implications. The dissent raised the issue of potential consequences if the U.S. were to allow citizenship for children born to parents with no formal allegiance to a country, implying this could lead to a dilution of intended scope of U.S. citizenship. To hold that the 14th Amendment covers the children of aliens born within the U.S. is to extend its operation beyond its proper bounds. That would be Justice Harlan. I remember that one. I just didn't note it. So in conclusion, I've still got a little bit more to go, but remember IRAC, issue, rule, analysis, conclusion. The dissent took a restrictive view of birthright citizenship, arguing subject to the jurisdiction thereof required more than mere birth within U.S. territory. Justice Fuller believed that allegiance and the legal status of the parents were critical factors and that the majority's decision granted citizenship way too broadly, potentially undermining U.S. sovereignty. This perspective is contrasted sharply with the majority's reliance on English common law. And again, even at the time, English common law did not give citizenship based on that principle. It just didn't. And it still doesn't. If the Act of 1866 had not contained the words, and not subject to any foreign power, the children neither of public ministers nor of aliens in territory and hostile occupation would have been included within its terms on any proper construction, for their birth, would not have subjected them to ties of allegiance, whether local and temporary or general and permanent. There was no necessity as to them for the insertion of the words. There was no necessity as to them for the insertion of the words. I should know this. I wrote the damn thing. Although they were embraced by them. But there were others in respect of whom the exception was needed, namely children of aliens whose parents own local and temporary allegiance, merely remaining subject to a foreign power by virtue of the tie of permanent allegiance, which they had not severed by formal abjuration or equivalent conduct, and some of whom were not permitted to do so if they would, i.e., the Chinese. And I believe the emperor also of Japan had the same blanket law. And it was to prevent the acquisition of citizenship by the children of such aliens merely by birth within geographical limits of the United States that the words were inserted. 2 months after the statute was enacted, June 16th, 1866, right after the war between the states has ended, less than, a little over a year and a month. 14th Amendment was proposed and declared ratified in 1868. First clause reads, all persons born or naturalized in these United States and subject to the jurisdiction thereof are citizens of the United States and of the state and where they reside. And the state and where they reside. The act was passed and the amendment proposed by the same Congress, and it is not open to reasonable doubt that the words subject to the jurisdiction thereof in the amendment were used as synonymous with the words and not subject to any foreign power of the act. Jurists and statesmen referred to in the majority opinion, notably Trumbull and Reverend E. Johnson, concurred in that view. Senator Trumbull saying, what do we mean by subject to the jurisdiction of these United States? Not owing allegiance to anyone else. That's what it means. Well, if you're an illegal alien, how are you not owing allegiance to someone else, another country or foreign power? It's impossible. Till you've renounced it, you do. Now, all that this amendment provides is that all persons born within the United States and not subject to some foreign power, for that no doubt is the meaning of the committee who have brought the matter before us, shall be considered as citizens of the United States. This was distinctly so ruled in Elk v. Wilkins, 112 U.S. 94, and no reason is perceived why the words were used if they apply only to that obedience which all persons not possessing immunity therefrom must pay the laws of the country in which they happen to be. I did not mean to end that with a preposition. Don't ever do that. Don't ever do that. Don't end it with preposition. And don't do orphans when you do your pages. Dr. Wharton says that the words subject to the jurisdiction must be construed in the sense which international law attributes them, but that children of our citizens born abroad and of foreigners born in the United States have the right on arriving at full age to elect one allegiance and repudiate the other. That's true, too. I have a cousin, first cousin, who was born in Panama, and he was born in the Canal Zone, but when he went to the military, he still had to renounce citizenship to it and give up Panamanian citizenship. Even though technically he could have kept them because he was a Canal Zone, Congress allowed it, etc. Constitution and statutes do not contemplate double allegiance, and how can such an election be determined? By Section 1993 of the revised statutes, citizenship of the children of our citizens born abroad may be terminated in that generation by their persistent abandonment of their country, while by Sections 2167 and 2168, special provision is made for the naturalization of alien minor residents on attaining the majority by dispensing with the previous declaration of intention and allowing 3 years of minority on 5 years residence required, and also for the naturalization of children of aliens whose parents have died after making declaration of intention. By Section 2172, children of naturalized citizens are to be considered citizens. And remember, too, I think it wasn't until 1923, the 14th Amendment didn't cover Native Americans at all. They were not considered citizens until then. So, and that was just done by legislation under the 14th Amendment. They just added it. That's it. So, to sit there and say, oh, well, it was anyone that came in the United States was automatically, including the Chinaman, was born here, was a citizen. Well, if that's the case, when the hell weren't the Native Americans allowed? Why? If they're not going to be allowed citizenry, and it had to be passed by Congress, why in the hell would an illegal immigrant be allowed that? The same would be true and is for the children of diplomats. A child of a diplomat born here, they're not entitled to it. Now, I'm sure there's some silly ass law that allows it, but they're not allowed that just by standard statutory reading of the amendment. They're not allowed it. They're an excluded portion. The point, however, before us is whether, and this is another quote, whether permanent allegiance is imposed at birth without regard to circumstances. Permanent until thrown off. Again, they have to come here and declare it and say, hey, I'm done with Honduras. And another allegiance acquired by formal acts, not local and determined by a mere change of domicile. Chief Justice Waite, let's see, I think it's in Happersett. I think this is his quote. I do not insist that, although what was said was deemed essential to the argument and necessary part of it, the point was definitely disposed of in the slaughterhouse cases, particularly as Chief Justice Waite in Minor v. Happersett remarked that there are doubts which, for the purposes of the case then in hand, it was not necessary to solve, but that solution is furnished in Elk v. Wilkins, where the subject received great consideration. It was said, by the 13th Amendment of the Constitution, slavery was prohibited. Okay? We're back to that. Got to talk about it. The main object of the opening sentence of the 14th Amendment was to settle the question upon which there had been a difference of opinion throughout the country and in this court as to citizenship of free Negroes, Scott v. Sanford, and to put it beyond any doubt that all persons, white or black, whether formerly slaves or not, born or naturalized in these United States and owing no allegiance to any alien power, this is what they're going to have to use. This is the route they're going to have to use in order to sway the court. I don't see any other. I really don't, because I think people are just so enamored with the idea of this is just the way it is. This is it. That's it. This is it. It's not a good argument. Yeah, it's been 127 years. Yeah, okay. It was bad law. So was Roe. And it got changed. You just have to make the argument. Hopefully they can persuade them. Owing no allegiance to any alien power should be citizens of the United States and of the state in which they reside. Slaughterhouse cases. Stratter v. West Virginia. So our takeaway, and we'll close it off with this, because I'm not going to sit here and do this all night, and I don't think anybody wants to watch a 2-hour video on Wong Kim Ark. It'll drive me nuts. So let's try to wrap it up. In the U.S., Wong Kim Ark, the Supreme Court did not explicitly address the issue of whether a child born to illegal aliens could be a citizen. The case primarily concerned the citizenship of Wong Kim Ark. Again, we're back also to these nationwide jurisdiction or injunctions. Does the case apply to everyone or just him? I think at the Supreme Court level, it's pretty plain that it applies to everyone. But somebody's going to issue a ruling in a district court. It's coming. They're going to do it. They're going to reaffirm it and say, wouldn't be surprised, another injunction gets issued. And they're going to say, you, Supreme Court, we don't care, not doing it. Because who's going to hold the judge? Look, it's the fox guard in the hen house. Who the hell is going to hold the judges accountable? Like nobody. Congress doesn't have the balls to do it. So, doesn't matter. It doesn't matter. No one's. They don't have to obey the Supreme Court. They're supposed to. They can get reprimanded and don't you do that? And fuck you guys. I don't care. Get your bitch ass in the kitchen and make me some pie. What's the Supreme Court going to do? Nothing. Without acquiescence, the court has no power. If a court issues an order and says to the sheriff, go seize person X, and the sheriff says, fuck you go seize them. Yeah, that's the end of that. Judge can't do it. So we'll see. But unless they acquiesce to the authority of the Supreme Court, they're just going to keep doing this. They don't give a shit. The court ruled, the case primarily concerned citizenship of Wong Kim Ark, who was born in the U.S. to parents who were lawful permanent residents but not citizens. The court ruled that Wong was a U.S. citizen of the 14th Amendment, which grants citizenship to all persons born or naturalized in the U.S. subject to the jurisdiction thereof. The court analyzed the meaning of subject to the jurisdiction thereof. They did, in this case, they did. And I would love to go over the case, but it's, I think, damn near 100 pages, which is that weird Supreme Court formatting. It's like this, about 5 inches wide by 12 inches in length. So it's really not that long, but it is, even on regular paper like this, it's well over 50. And you have to read that kind of shit in law school. And I promise you, by your third case in a night of having to brief something, you're going to just sit there and go, you'll be looking for something to like bloodlet yourself, like a pen or something, just to cut your wrist. You'll be miserable. People that love it, I don't know anybody that loves it after law school. I mean, briefing cases is not like it is on YouTube or Rumble or whatever. It's just not the same. So when you get into law school, you have to deal with the Socratic method, which is the way they teach law school. And the Socratic method is there to embarrass the shit out of you. And it's hard. It's really difficult. I used to have a professor in my first year. Actually, I took him for conflicts too, which is like, I think it was at the end of my second year. But there's a movie called, I think, The Paper Chase. I think it's Paper Chase. Made in like late 70s, early 80s, about Harvard Law School. And the professor in that would tell, like, Mr. Johnson, did you read, please brief, Wilkins v. Thomas. Please stand and deliver. And that meant stand your ass up and brief the case. And the whole time he's sitting there popping questions at you like an appellate, like an appellate argument. And his whole intent is to make you look like an idiot. The end. So just know that when you go to law school, they are there to make you fail that first year. Those professors, at least your first semester, their goal, and they won't tell you this, but it's their goal to fail you, to get you to leave and drop out because you're not the type that they want. They don't want someone that'll give up. It's kind of like going in the military, going to boot camp. The court analyzed the meaning. It concluded this phrase applies to virtually all children, regardless of their parents' nationality, except for specific exclusions such as foreign diplomats or enemy soldiers that are in hostile occupation of the United States. So if the Mexicans invaded us, obviously their children that they have would not be, excluding to a U.S. mother, would not be citizens. Parent status. Ark's parents were not U.S. citizens, but were lawfully domiciled in the U.S. The court explicitly recognized their allegiance while residing here, which was a critical factor in its reasoning. So even there's still useful benefit to the actual case itself for the administration to use to try to not necessarily overturn it, but to tweak it a little bit. That's important. I hope that when they do this, I think that's the route they'll take. You're going to have to take the dissent's point. You're going to have to formulate an argument with it, but you're also going to have to use the finding of the actual justices, the majority, and their opinion that they recognize that although they were not citizens, they were still here lawfully. That's the kicker. You can still say, look, it applies to everyone, but they got to be lawfully here. They have to be here lawfully. If they're here lawfully, then it applies. If you have a baby, they're a citizen. Illegal immigration was not addressed at the time. The concept of illegal immigration, Tourette's is getting bad today. The concept of illegal immigration, as we understand it today, did not exist. Obviously, they had no idea this was going to happen. Even back then, with the influx of the Chinamen to build a shitty railroad, the idea that millions would flood in was not. no one had any conception of that. Um, unless, hey, if it's there and you could find it, send it to me. I'd love to read somebody's writings on it. There was contemporaneous, but I highly doubt it. While the decision in Ark established a broad interpretation of birthright citizenship, subsequent debates have raised the question of whether the ruling applies to children born to parents who are in the U.S. lawfully. The court's decision does not contain language that specifically limits birthright citizenship based on the legality of a parent's presence. In summary, the court did not decide whether whether a child born to undocumented or illegal aliens are citizens, but the broad principles articulated in the decision have been interpreted to support birthright citizenship regardless of their status. That's what I think. Well, I know I keep saying that's what's going to have to change. That's it. Or Congress is going to have to get off their freaking ass, take their head out of rectum, remove their head from their anus, and do their freaking job. They've got to do their job, which is to pass a law. They love passing laws for everything else. They can damn well pass a law for this and make it easy. We shouldn't have to go to the courts for this all the time. This is absurd. Now, do I think that it's going to still go to the court if they change the law? And they absolutely, it's going to happen. It's inevitable. So in the end, it may not matter. But they still need to do their damn job. They get paid a pretty good salary. They just need to do their job. It's like Nick Saban always says, do your damn job. Do your damn job. Execute, do your job. Things will work out. You'll succeed. Although, I guess you could argue that maybe we don't want them to succeed, so they'll quit passing laws. Maybe so. In the end, the amendment gives Congress the sole authority to enforce the amendment by legislation. Remember, that's the last sentence of the amendment. They can enforce it by appropriate legislation. And they can, if not have already, set grounds where illegal aliens are not subject to the jurisdiction of the United States, nor in allegiance thereto, and their offsprings would not be U.S. citizens. I would love, see, did I actually get the quotes? I want to see if I got the quotes. Probably not. I'm probably too dumb to have actually gotten the quotes. Let's see. No, I didn't. There are a lot of quotes. Let me see if I can find it real quick. Stop sharing. Damn it. Come on. Thank you. All right. Can't believe I thought I had gotten them. Okay. Senator Jacob Howard of Michigan, one of the sponsors of the 14th Amendment. This amendment does not propose to cut off the right of citizenship to the children of foreigners. This is this guy's opinion. It does not apply to persons born in the United States who are foreigners, aliens, or who have belonged to the families of ambassadors or foreign ministers. That was May 30th of 1866. He introduced the language subject to the jurisdiction thereof, and he was clarifying it. Senator Trumbull of Illinois. What do we mean by complete jurisdiction? Not owing allegiance to anybody else. Let me see if I can't share this. That would be great. Well, thank you, Relax Sweater. I hope you're still with me. I'm sorry that I haven't been paying attention to the chat. I'm horrible about paying attention to the chat. It's hard, at least on Rumble it is, because even though I'm sharing the screen, I can't see both. Dang it. Let me see if it maybe, and see, I don't know that my text got to you as well, because you're on YouTube. And see, now it's popping up as me on YouTube. I don't know. This is weird. They got to fix this shit with Rumble. But it works the same as StreamYard. At least I'm shaking everything. It works the same as StreamYard, which is like $40 a month. This is free. So I take it. John Bingham of Ohio, framer of Section 1 of the amendment, I find no fault with the introductory clause of the Civil Rights Act of 1866, which is simply a declaratory of what is written in the Constitution, that every human being born within the jurisdiction of the United States of parents not owing allegiance. That's what I was going to do. Damn it. Share. Window. ChatGPT. There we go. There we go. Not owing allegiance to any foreign sovereignty is, in the language of the Constitution itself, a natural born citizen. March 9th of 1866. Bingham here implied that allegiance of the parents mattered, but scholars debate whether he was referring only to foreign diplomats or invading armies, not to ordinary immigrants. I have a hard time believing that. Edgar Cowan is the child of a Chinese immigrant in California to be a citizen, is a child of a gypsy born in Pennsylvania a citizen. I am not yet prepared to say that I would consent to make a citizen of a Chinaman. Call it, you might not like it, but that's what they thought. That's what we have to go by with the originalist interpretation. We either live and die by the sword, or we don't. Cowan objected that the amendment would include people he believed should be excluded, such as a China immigrant coming over here, build a shitty walk, and Mongolian beef. Gonna serve some Mongolian beef. Oh, I'll come over here and have some Mongolians. Oh, Mongolians. His concern implied the amendment was broad in scope in the argument, but his arguments did not prevail. So I think their reasoning, though, for doing that was to make damn sure that these former Confederates, remember, this amendment passed, and almost immediately at the same time, they threw out every state government in the South because they had reelected all the same dudes that hadn't died, because those guys didn't die because they were rich, so they didn't go to fight. They reelected the state legislatures prior to the war. So they came in and said, nope, you're no longer states, you're military districts. That's Reconstruction. And a very short sentence, that's Reconstruction. You're no longer states, you're individual districts. We're going to run you as a military district. That's it. Done. So I think they were trying to make sure that people that had just been freed, 600,000+ men had just died. 600, that's 12 million today. 12 million Americans had died to make these men and women citizens free. Even if it wasn't the direct intent of the soldier fighting, and most it was not. Anybody that thinks that is a moron, because they were just as racist then as today, even more so. North and South, they did not care. And most Southerners, I think it's less than 10% were landowner or slave owning, did not fight for the fact that somebody else could own property. They fought because, as it's frequently quoted, because you're here. That's it. But these same people who were the 10% had gotten back into power and were depriving freed blacks, or as they said, free Negroes, of citizenry. And so, hence, not only the 13th Amendment had to be passed, but they had to do something a little more, because in between the two, you had a Civil Rights Act that still didn't work. And it was 1866. I knew I was going to, yep, here it is, 1866 Civil Rights Act, precursor to the 14th Amendment. It just didn't go far enough. Did not go far enough. They were still skirting it. All persons born in the United States and not subject to any foreign power are hereby declared to be citizens of the United States. Simple. I wish they had just left that. That would have been easier. But they didn't have an amendment. So it was too broad. They had to pass an amendment to make sure they could enforce it. All right. Well, that's what I'm going to end it on. Thank you for joining me. I hope it's been of some help. I know it's not a sexy topic. And for a lot of people, I think people are getting freaking sick and tired of hearing about it. It's going to happen, though. It's going to come down to whose argument is what, and well, it's always that. Whether or not the argument is that it's just because, the amendment still applies, the original ruling still applies. They're not going to argue that. potentially they're not going to argue that it doesn't apply. It's just to whom it applies. Do you have to subject yourself fully to the jurisdiction of the United States? And what the hell does it mean, since Congress hasn't stated it? Then again, they may take the dissent's point of view and just say, look, justices, the decision was wrong. Look at what the hell we're going through. This is bad. We are invaded. We can't sustain it. This is bad. I don't know. It's going to be one of the two. Otherwise, you go in with any other argument, you fail. You fail coming in the door. So I hope this helps. I spent quite a bit of time to try to type it out. Kind of what you do in law school. It's not quite that good. I would not have turned it in. But I hope it allows you to get a better viewpoint on, it's probably the last one I do on this. It's interesting to see some of the law tubers changing their opinion so slowly. I don't think people really read the opinion, and I encourage you to read it. Like I said, it's pretty long because you're going to read both the actual opinion and you're going to read the dissent, which would be Harlan. It's Justice Harlan, and I just said his name. I can't think of it now. There's several. There were several that dissented. So, oh, I'm sorry. Relax, sweater. You were born on an army base in Germany, and when I joined the Navy, I had to officially correct. Absolutely, that is correct. You have to renounce it when you go into the military. That's just how it works. So, and look, it's not because they don't want people to join or they want to treat them differently somehow. It comes down to loyalty. Who are you loyal to? You know, we shouldn't have to sit there and worry about people that are dealing with classified information, whether or not they're loyal to the United States. So, you know, in the end of the day, I'm extremely, in my primary job, I do in-house, along with regular legal work, I do in-house counsel work for a company. And the issues come up. And it's hard to be able to sit there and tell, you know, your boss or people, hey, buddy, you're going to have to go back. You're going to have to go back, come in the right way. You know, either take up the government's offer to fly you back and be first in line and use what you've learned here to make you money in your home country. Because a lot of these guys, like especially in construction, people don't realize this. Oh, who are we going to get to pick our cotton? It's not that. We can't get, look, I'm being honest, we can't get white and black guys that are Americans to get off their ass to go work construction. Part of that is there's the illegals are really, really screwed over and treated as slave labor almost, you know, 10, 15 an hour when 25 would be your normal pay per hour to even lay brick with no training. You get guys that have some training behind them, and buddy, that rate goes up real quick. But these guys who come over, man, they look, they come over, they learn a trade, they go back, and with just the little bit of money they've saved, they can start an empire of construction. So do I feel bad? Yeah, some of them really and truly want to be here. Flat out. They have no care for Honduras or Colombia or wherever they're from. They just don't care. They hate the place. They don't want to go back. You know, they have family here. You know, it sucks that they can't get their shit processed the correct way. And some of them have tried to. And the government just doesn't process it. It's that bad. So the system is broke and does need to be fixed. Unfortunately, for now, we got a big problem. And this is going to have to be fixed. It really needs to be fixed by Congress, but I don't foresee that happening. They're a bunch of lazy cowards. So, all right. Thanks, guys, for bearing with me. I appreciate it. Hope it's giving you some insight. And this will be the last one I do on this. I'm done. I think the next one I'm going to do, next video, a lot different. I'm going to do one on Ayrton Senna's fatal accident. I know that sounds like, well, what the hell's that got to do with the law? Well, Italy prosecuted the Williams F1 team and its principal, the car's designer, Adrian Newey. I think the last case wrapped up in like 2002, somewhere in there, about an 8-10 year saga. And it's an interesting case. They don't have the same, I wouldn't race there. We have assumption of risk in the United States where you get in a race car, you may die. That's kind of the risk of being in a race car. They don't have that in Italy. So they prosecuted. And there was some, I wouldn't call it negligence, but there was things done at Senna's bequest that most likely caused the accident. Any other day of the week, he would have lived. He'd have been fine. He just got very unlucky in that the wheel and wishbone of the car came up and hit him in the helmet and killed him. So I thought it would be a cool little different. No one's, as far as I know, you can watch videos on it, but no one's done a in-depth legal analysis of it. And I'm going to do the best I can because obviously I'm not an Italian lawyer, nor do I want to be. Hell, half the time I don't want to be a U.S. lawyer. I'm sick of the court system in itself. It's not an equitable system. But anyway, that's a topic for another day. All right. Thanks, guys. Appreciate it, y'all. Until next time, roll tide.